We're going to get started. Good afternoon, everyone, and welcome to this session on the Solomon Amendment. I'm going to start off by introducing Kathi Westcott, and she's going to talk a little bit about Service Members Legal Defense Network, the organization that she represents, and the U.S. military's Don't Ask, Don't Tell policy. As you might have noticed from the title that I selected, I have it was intentionally sort of inflammatory, and I think it worked. Pizza helps too. So it is an issue over which people have greatly diverging opinions, and I think hopefully we're going to traverse the entirety of that today. We're not just going to be focused on one angle. So to start, Kathi Westcott is the Deputy Director of Legal Affairs for Service Members Legal Defense Network. She's been working in that capacity since 1999, and in that role she is charged with leading SLDN's efforts in opposition to the Don't Ask, Don't Tell, Don't Pursue, Don't Harass policy, and she will of course get into that a little bit more. Is also pushing back against the military's anti-sodomy policy in light of the Lawrence decision. And she sort of cut her teeth in social justice work in D.C. And has really sort of taken hold of some fascinating issues in this area. As she said on the way here from the airport, this is, in her mind, sort of federally sanctioned discrimination. So you can't get any more controversial than that. So without further ado, here's Kathi.
Thank you. Thank you very much to Outlaw and ACS for inviting me down here. Organizationally, we think it's very important to do as much public speaking as we possibly can. Outreach and education is a priority for our organization. Service Members Legal Defense Network is a national, nonpartisan, nonprofit organization. We started almost 12 years ago as a legal services and watchdog organization, providing direct legal services to members of the military impacted by the Don't Ask, Don't Tell policy. About 3 years ago, we decided to add a policy component to our organization, which meant that we cut back on our attorneys and hired a lobbyist because we really believed that while we were doing very good work in representing members of the military, we weren't making the difference that we needed to make on the issue, and that we wouldn't make the lives of our clients better until we repealed Don't Ask, Don't Tell. So we did exactly that. We hired a lobbyist, and last year helped with the introduction in the House of Representatives of the Military Readiness Enhancement Act. It has not yet been introduced in the Senate, but we hope the companion bill will be introduced in the Senate this coming year. And the whole purpose of that act, and we actually have a one-pager down here and other information about the organization down here if you're interested afterwards. The whole purpose of that act is to repeal Don't Ask, Don't Tell and replace it with a law that allows people to serve openly. Let's talk a little bit about Don't Ask, Don't Tell itself. 10 U.S.C. 654 is the law. Don't Ask, Don't Tell is not a policy, it is not an executive order, it is not a regulation. It is a law that was passed by Congress and signed by the President. The ironic part about all of this is that the law, 10 U.S.C. 654, only has there's only two words that are different from the regulatory ban that was created by the military in the 1980s. That regulatory ban said that homosexuality is incompatible with military service, and therefore all gay people will be separated from the military. Don't Ask, Don't Tell, 10 U.S.C. 654 says homosexual conduct is incompatible with military service. That's the only difference. Don't Ask, Don't Tell is a ban on gays and lesbians and bisexuals serving in the military. And whatever you hear in the media to the contrary is not truth in practice. As I said, for the last 12 years, we've provided direct legal services to people in the military fighting to stay in, fighting for retention. With respect to the specific law itself, it does not contain a don't ask provision. There is no don't ask language in the law. That is only in implementing regulations, which means at any time, at the discretion of the Secretary of Defense, he can lift the don't ask regulatory provisions and start asking again at a session when you enter the military, and also allow for asking once you're in the military. The only thing of the don't ask, don't tell, don't pursue, don't harass long title, the only thing that is actually in the law itself is don't tell. Back in the debates in 1992 and 1993, everyone who testified in Congress and the congressional members themselves basically testified that don't ask, don't tell would create a zone of privacy. You could be gay as long as you weren't public about it. We'll kind of put it in those terms. Realistically, through the practice of how don't ask, don't tell has been implemented, don't tell means that you are not allowed to tell anyone anywhere at any time. I have had clients that were outed by their parents. I have had clients that were outed by ex-husbands, ex-wives, ex-girlfriends, ex-boyfriends. Don't tell is not about a service member not telling the military. Don't tell has become about being completely closeted in your life, not even able to be out to anyone in your private life, because any statement can be used as evidence to separate you from the military. Again, what is a little bit ironic is that at the time that Don't Ask, Don't Tell was being debated, all of the Department of Defense's own research, and DoD does its own research. They do its own social science, economic research. All of the research papers that had been contracted by DoD or done by DoD researchers themselves had said that gays serving openly in the military would not be a problem. And the research started back in the 1950s. All of those papers were hidden, or they tried to hide them during the time of the debates. So even the military's own researchers cannot find ways in which having people serving openly gay will in fact impact unit cohesion, discipline, morale, which is what the military uses as its explanation for not having people serving openly gay. Realistically speaking, whether you're pro-military or anti-military, and please understand that SLDN is not an anti-military organization. In fact, we differ from a lot of the people supportive of the fair suit in that we believe the military should recruit on campus, but we believe the military should recruit gays and lesbians and bisexuals in addition to everyone else. The military is the largest employer of 18 to 25-year-olds in this country. 80% of the people discharged under Don't Ask, Don't Tell are between the ages of 18 and 25. The military is the largest educational funder in this country. Again, 80% of the people discharged under Don't Ask, Don't Tell are between the ages of 18 and 25. More than 10,000 people have been kicked out over the last 11 years just because of their sexual orientation. Not because they're not able to, not equipped or skilled or trained to do their job, but just because they have been found to have engaged in homosexual conduct. Homosexual conduct defined by the law, 10 U.S.C. 654, is defined as either a statement, an act, or marriage or attempt to marry someone of the same sex. A statement can be either verbal or nonverbal, and an act can be anything to include dancing with someone of the same sex or holding hands with someone of the same sex. And I mean, I can talk for hours about anecdotal stories because in the 7 years I've been at SLDN, I've probably had 300 clients or more. In the last year, and we do kind of keep some statistics internally, last year we had over 1,200 requests for assistance. We had over 300 active cases. Currently, that is split up between myself and our paralegal. So it's me and our paralegal doing all of those cases, which means that if you would like to come and have a really cool summer internship, we are happy to have you. You know, again, in kind of thinking about the ironies of Don't Ask, Don't Tell, gay discharges go down in times of war. Historically, they always have. When the military needs bodies the most, and they need skilled, trained people, gay discharges go down. Over the last 3 years, gay discharges have decreased a good 40 to 50%. They went down they went down during the Korean War, they went down during the Vietnam War, they went down during the Persian Gulf War, they're going down again. They have always spiked after an armed conflict, and so we will be interested to see what happens once we start to see major pullouts from Afghanistan and Iraq. Very briefly, in terms of the Solomon Amendment and SLDN, you know, again, from our position, we believe the military should have the best and the brightest, and that includes lesbian, gay, and bisexual people. We have filed an amicus brief in the fair litigation. And Professor Chemerinsky is going to talk specifically about the fair litigation. Our amicus brief is very restricted to the issue of military deference and our beliefs that military deference doesn't apply in this case and why. But we also are believe it's very important to participate in amelioration efforts, which is why we travel all over the country as much as we possibly can to do educational work about the underlying discrimination, which is Don't Ask, Don't Tell. Whatever you believe about the Solomon Amendment, Don't Ask, Don't Tell requires you to be fired just because of your sexual orientation or your alleged sexual orientation. It has nothing to do with your performance. It's just about your status of who you engage in relationships with. And it's the only law in the country, not just federal law, it's the only law in the country that requires that you lose your job because of that. In addition to the legal services that we do and the Military Readiness Enhancement Act, which I talked about briefly, we're also playing in the area of sodomy. The military still has a sodomy statute. It is illegal for members of the military to engage in consensual sodomy, regardless of sexual orientation, regardless of gender of the people involved. And they define sodomy very broadly. After the Lawrence Supreme Court decision 2 years ago, we have submitted a number of briefs in the military appeals courts saying that Lawrence applies to the military and therefore the military sodomy statute is no longer constitutional. It's an ongoing battle. The highest court in the military has said they do believe that Lawrence applies to the military, but they have then kind of imparted a 3-part test to review case by case every consensual sodomy decision there is. Most of the people who are in military prison, and you do get a federal conviction for consensual sodomy, most of the people in military prison for consensual sodomy are heterosexual, oddly enough. The top end of the sentence is 5 years in prison. So we believe it's a pretty significant issue to fight, and it also is the underpinnings of Don't Ask, Don't Tell itself. Finally, the last thing I'll mention is that we have filed a case in Federal District Court in Boston on behalf of 12 plaintiffs, all of whom were kicked out under Don't Ask, Don't Tell in the last 3 years. The only thing that our plaintiffs are seeking are to be reinstated in the military. We're not seeking monetary damages, we're not seeking back pay, anything along those lines. The only thing that they want is to go back into the military. The 12 of them have all been honorably discharged. They have over 60 years of combined military experience. Our greatest time in service was over 14 years. Our least time in service was a little over a year. We have gone through oral arguments on a motion to dismiss. The government has moved to dismiss our case. We've had oral arguments this summer. We're now waiting on the judge's decision. We're pretty confident that we'll make it through the motion to dismiss, and hopefully we'll be able to put Don't Ask, Don't Tell on trial next year. That's the goal of our multi-pronged fight into repealing Don't Ask, Don't Tell. And at that point, Justin?
Good afternoon. My name is Justin Wilson. I'm a 2L here at Duke. I'm the publicity chair for Outlaw, and it is with great pleasure that I introduce Professor Erwin Chemerinsky to talk about the Fair against Rumsfeld litigation.
Thank you. Thank you for inviting me to speak today. Thank all of you for coming today. In the 28 years since I graduated from law school, I've been in a lot of different roles. I've been a lawyer, I've been a teacher, I've been an elected official, I've been an appointed official. I've even been a defendant in a lawsuit. But never before have I been a plaintiff in a lawsuit. And I'm very proud to be a plaintiff in the lawsuit that's referred to now as Rumsfeld versus Fair, and that's already been referred to. The reason it's so important to me is that as a law professor, I think it's essential that every aspect of the law school where I teach be open to all of the students. That our law school has to be clear that it does not discriminate, that does not support discrimination on the basis of race, or ethnicity, gender, religion, or sexual orientation. I think it's essential that the law school have a policy that says that it will not allow any employer to use its placement office facilities if that employer discriminates on the basis of race, gender, ethnicity, religion, or sexual orientation. This was already described because of a federal statute. The United States military does discriminate on the basis of sexual orientation. And thus, I think it's crucial that law schools express as a policy that they will not allow the military to use law school career service office facilities. Just as the law school will say that no employer that discriminates on the basis of these grounds should be entitled to use law school facilities. Well, that's exactly what the lawsuit of Rumsfeld versus Fair is all about. So let me talk a little bit about first what is the Solomon Amendment, which is the focus of the Rumsfeld versus Fair lawsuit. Second, tell you a little bit about the procedural history in Rumsfeld versus Fair. And then third, finally, talk about the substantive issues that are going to be before the Supreme Court 2 weeks from today on December the 6th. The American Association of Law Schools includes all accredited law schools in the United States. And it's long had a policy that prohibits its member schools from discriminating on the basis of race, or ethnicity, gender, religion. Some time ago, sexual orientation was added to that list, grounds upon which law schools cannot discriminate. Most law schools in the United States, consistent with this, adopted a policy that they would not allow military recruiters to come and use law school career service facilities. Now, in most instances, the military recruiters could still come on campus. They could go use the ROTC office on campus. In some instances, they would just go to a building near campus if there wasn't an ROTC facility. At the University of Southern California, where I taught for 21 years, the military simply went to a hotel directly across the street from the law school. Not coincidentally, that's the same hotel that all of the other employers used when they went to meet with students. The only difference is that the military couldn't advertise what it was doing using career service office facilities. The career service office wouldn't do anything to facilitate the military doing this. And law schools, of course, did this consistent with an overall anti-discrimination policy. They did so for the reason I already suggested, that it's so important that the law school have as a message that every aspect of the law school is equally available to all of its students. Well, in 1994, a congressman from New York by the name of Gerald Solomon expressed concern over the fact that some law schools were not allowing the military to use career office facilities. And so Representative Solomon introduced a bill that was adopted into law that said that any institution that refuses to allow the military equal access will lose Department of Defense funding. Phrased in that way, it didn't matter very much to law schools, because it appeared that it would simply mean that any law school that excluded the military would no longer get Department of Defense funding. To my knowledge, few, if any, law schools get Department of Defense funding. In fact, New York University Law School adopted an official policy saying they would not take any Department of Defense money, which was easy for them to do because they weren't getting any Department of Defense money. In 1997, Representative Solomon introduced a new bill to say that those who did not allow the military equal access would also lose funding from a whole series of federal agencies. And then in 1999, Representative Solomon introduced yet another bill that was adopted into law that was much more draconian. It essentially said that any university that had a part that refused to allow the military equal access would not be able to receive virtually any federal funding. Now, law schools don't get much in the way of federal money, but universities are very dependent on federal money, especially in areas like engineering, medical schools, science departments. They're tremendously dependent on federal funds. And the 1999 version of the Solomon Amendment would basically have meant that any law school that refused to allow the military equal access to placement facilities could face the entire university losing federal funds. As I say, in 1999, Congress adopted this, but the Clinton administration essentially ignored it. It was only in 2001, after September 11th, with a different administration, that the policy was adopted by the administration that they were going to aggressively enforce the Solomon Amendment. They went to several universities, among them Harvard, Yale, and the University of Southern California, and said that unless they allowed the military to use law school career service facilities, the United States government would basically cut off all federal funds. I was teaching USC at the time, and as soon as the General Counsel's Office got this notification from the Department of Defense, they immediately instructed the law school that they had to allow the military to use career service office facilities. And of course, the reason was the university wasn't going to risk loss of all federal funds. Immediately, law schools across the country that had previously excluded the military were told by the university administration, the General Counsel's offices, that they had to allow the military to use career service facilities. And in fact, in 2004, the Solomon Amendment was amended yet again to say that law schools, the universities, must in every way give the military equal treatment, equal access to all aspects of university facilities. So that's what the Solomon Amendment is. It's what's being challenged before the Supreme Court now. Simply put, it was a federal law attached to Congress's spending power that says to universities, if they take federal funds, they can't in any way discriminate against the military. It's all about forcing law schools to allow the military to have equal access to career service offices. Well, the second thing I wanted to talk about then is the lawsuit that was brought to challenge this. Right around the time that this was happening, a group of law professors got together, to some extent got together by phone and electronically. A bit of it was done in person, with the thought of bringing a challenge to the constitutionality of the Solomon Amendment. The argument was that it violated the First Amendment rights of law schools, law faculty, and law students. And led by a Boston College law professor, Kent Greenfeld, a new organization was created. The organization is called Forum for Academic and Institutional Rights, the acronym being FAIR. If Congress could come up with an acronym for Patriot Act, coming up with each letter of that standing for a word, certainly those on the other side of the political spectrum could also try the rhetorical strategy. And so it wasn't coincidental that this organization is called FAIR. The organization was created for the express purpose of bringing the challenge to the Solomon Amendment. To this point, the only thing that FAIR has ever done is challenge the Solomon Amendment. There is talk about broadening what we do in the future. I agreed at the time to be a member of the board of directors of FAIR and have been so ever since. We then recruited a terrific lawyer. I think he was still then at the Brennan Center in New York and soon went to work at a law firm in New York, a man named Josh Rosencrantz, who was willing to do the case pro bono. And Josh has been the lawyer for FAIR, arguing the case at every step along the way. And Josh will argue the case in the Supreme Court 2 weeks from today. As strategy discussions went on, it was decided that it would be good to have not just FAIR be a plaintiff, but also to include a couple of law professors and a couple of law students as plaintiffs. Sylvia Law, who is a law professor at New York University, a very prominent one, agreed to be a named plaintiff, and I agreed to be a named plaintiff. And 2 law students, or they were then law students, they're no longer law students, also agreed to be named plaintiffs. And if you go back and I've got a copy of the Third Circuit decision here, and if you read the caption of the case, it says, Forum for Academic and Institutional Rights, New Jersey Membership Corporation, and then later added in Society for American Law Teachers. It says, then it lists the law students Pam Nickisher, a New Jersey resident, Leslie Fisher, a Pennsylvania resident, Erwin Chemerinsky, a California resident, because I lived there when it was filed, Sylvia Law, a New York resident. We were the plaintiffs in the lawsuit. Hence, I say that I was now, first time ever, a plaintiff in a lawsuit. And of course, what we said in declarations to the trial court was that as law professors, we believe that the educational institutions where we teach are adversely affected if our educational institutions participate in discrimination against gays and lesbians. We expressed our view that I said to you at the outset of how important it is that every aspect of our law school be equally open to all of our students, and that we believe that the law school has to set out as a message that they believe that all students are equally entitled to access to career service facilities, and that discrimination against any of our students is wrong, and as a result, discrimination by the military against gays and lesbians is intolerable. Lawsuit was filed in federal district court. The district court judge in New Jersey ruled against us, ruling in favor of the government, finding no First Amendment violation. Almost exactly a year ago, on the Wednesday after Thanksgiving, the United States Court of Appeals for the Third Circuit, in a 2-1 decision, reversed the district court. Samuel Alito was not on the panel deciding this case. That was his court. The Third Circuit 2-1 held that the Solomon Amendment violates the First Amendment. The government then filed a petition for writ of certiorari. As I said yesterday, I think, to my federal courts class, one of the best predictors of whether the Supreme Court's going to hear a case is if the lower court struck down a federal law. Almost always, if the lower court declares a federal statute unconstitutional, the Supreme Court's willing to take that case. So I don't think it was a surprise to any of us when the Supreme Court granted cert last spring in the case of FAIR versus Rumsfeld, or since we won in the Court of Appeals, it's formally titled in the United States Supreme Court, Rumsfeld versus FAIR. So that's procedurally where it is. It's been fully briefed. It will be argued on December 6th. Yesterday, the Supreme Court announced that there will be an immediate audio tape released the day of oral argument. That doesn't happen very often. It happened in Bush versus Gore. Interestingly, the Supreme Court also announced that they're going to be releasing audio tapes in the 2 cases next Wednesday that touch on abortion rights. And they said so with regard to the Solomon Amendment case, Rumsfeld versus FAIR, which certainly shows an awareness of the justices of the public interest in the case and its social importance. So having told you what the Solomon Amendment is, having told you what the lawsuit it's been about, now let me talk finally about the substantive issues here. There's a well-established principle of constitutional law called the unconstitutional conditions doctrine. The unconstitutional conditions doctrine says that the government can't condition a benefit on people having to give up their constitutional rights. The government couldn't say to a welfare recipient, you can receive welfare, but only on the condition you agree never to criticize the government. that would be an impermissible, unconstitutional condition. And there are many Supreme Court cases that have said the government can't condition any benefit on the grounds that the person has to forego a constitutional right. Well, what the Third Circuit found here was that the Solomon Amendment does exactly that. It says that universities will receive a benefit, government funding, only if the universities give up their First Amendment rights. And the Third Circuit found there are a couple of ways in which the Solomon Amendment violates the First Amendment rights of universities. First, it's unconstitutional compelled speech. In a whole series of cases, the Supreme Court has said, just as there's a right to speak under the First Amendment, so is there a right to not speak. One case, if you studied First Amendment law, you might remember, is a case called Woolley versus Maynard. New Hampshire had a requirement that its license plates have on the bottom the phrase, live free or die. And this man kept taking metal shears and cutting out that phrase, live free or die, from his license plate. And he kept getting arrested. And the Supreme Court ruled in his favor. The Supreme Court said that's the government compelling his speech. One of the most famous Supreme Court decisions about the First Amendment was in the 1940s, a case called West Virginia Board of Education versus Barnett. The state of West Virginia required that its students salute the American flag each day. And the Supreme Court, in a very eloquent opinion by Justice Robert Jackson, said that violated the First Amendment. It was impermissible compelled speech. Well, the Third Circuit said that the Solomon Amendment is compelled speech, that there are many ways in which law schools will have to endorse the message of the military if they're required to give the military the same access to all other employers. And the Third Circuit went through examples of what law schools do to communicate the presence of employers on campus, and that the law schools would be communicating then a message that they disagree with. Law schools have an anti-discrimination message, and here they'd be having to communicate a message of the military that's implicitly inconsistent with it. Another ground that the Third Circuit found was a violation of the First Amendment was violation of freedom of association law schools. The Supreme Court has said that freedom of association is a fundamental right under the First Amendment. The Supreme Court has said that freedom of association includes a right of expressive association. That is, people can refuse to associate with others if it's inconsistent with the message that they want to communicate. The Supreme Court ironically articulated this most clearly in a case in the year 2000 called Boy Scouts of America versus Dale. James Dale was a lifelong scout and scout leader. He had risen to the level of Eagle Scout. He was then an assistant scout leader. And the Boy Scouts of America learned that he was gay. He was a student at Rutgers University, and he participated in a forum on emotional problems of gay and lesbian youth. Once that was reported in the newspaper and Boy Scout officials saw it, they then sent him a letter telling him he was no longer welcome to participate in scouting activities. New Jersey has law that says that private groups cannot discriminate on the grounds of race or gender or religion or sexual orientation. James Dale sued the Boy Scouts under the New Jersey state law. The Boy Scouts raised the First Amendment and freedom of association as a defense. The Supreme Court, in a 5-4 decision, ruled in favor of the Boy Scouts. The Supreme Court said the Boy Scouts have an expressive message that's anti-gay. The Supreme Court said in furtherance of that message, the Boy Scouts can exclude James Dale or other gays. The Third Circuit said, applies here as well. Law schools have an expressive message which is anti-discriminatory. The military, pursuant to federal statute, discriminates. Therefore, the law schools, in furtherance of their expressive message, should be able to exclude the military. As I say, both of these grounds were deemed independently by the Third Circuit to be unconstitutional conditions, and thus the Third Circuit declared the Solomon Amendment unconstitutional. Supreme Court granted review. Case is going to be argued in 2 weeks. I'm hopeful that the Supreme Court's going to affirm the Third Circuit and say that if law schools wish to exclude the military as part of their anti-discrimination policies, they should be able to do so.
Thank you,
Just
Kathy and Professor Chemerinsky. At this point, we're going to open it up for questions once we have this microphone problem resolved. The reason that I'm going to moderate is simply so that our webcast audience will be able to hear the questions. Ian, we'll have you start in just a moment.
I wholeheartedly support the political goals of the fair suit, but I'm worried about the waves that a victory could cause. Specifically, if the Supreme Court accepts the First Amendment theory that's being articulated in FAIR, doesn't that also apply to, say, Bob Jones University, when they want to, when they say that part of their expressive association or part of their expressive message is that they want to discriminate against, insert protected group here, and therefore things like the Civil Rights Act of 1964 shouldn't apply to them?
So the question, if I understand it correctly, is about the right of expressive association and how far that extends in terms of other kinds of discrimination.
It's only of concern if you believe that a victory for fair will increase the ability of, to use your example, Bob Jones University to discriminate. I don't think that it does. I think that if Bob Jones University already has a policy that it discriminates on the basis of, say, sexual orientation, and as a result, it won't allow recruiters on campus who are gay or lesbian. I think Bob Jones University has that right under Boy Scouts of America versus Dale. So long as the entity has an expressive policy that's discriminatory, Boy Scouts says it can discriminate in furtherance of it. I think what's the genius behind this lawsuit, and I can say that because I'm not responsible for this idea, and I'm just one of the plaintiffs, but I think the lawyers who came up with this is, why not use Boy Scouts of America versus Dale, which I regard as a profoundly homophobic decision, to advance the rights of gays and lesbians?
Wiley?
You mentioned that under Boy Scouts of America, private organizations have the, as I understand, have the right to not associate with certain groups. How does this affect public universities and public law schools versus private universities and private law?
The question is the distinction of how the Dale decision, applies to public and private universities.
A law school, we believe, is a form of expressive association. Certainly, whether it's a public law school or a private law school, there is association that's going on. Professors are associating with each other and with students. Students are associating with each other and with professors. And so we'd argue whether it is public or private, there's associational activity going on, and it's protected under the First Amendment freedom of association. Many law schools decided to join this lawsuit. Rutgers University, for example, was one of the first to do so, and it's a state university in New Jersey.
Teresa?
Kathi, can you talk a little bit about how your military deference argument differs from that in Solomon? I mean, in the fair litigation.
The question is how the military deference argument differs from the arguments advanced by the plaintiffs in the fair litigation.
I think SLDN decided to file our amicus brief concerning military deference because we also have our underlying fight against Don't Ask, Don't Tell. There's a long, if you don't know what military deference is, there's a long history in which the Supreme Court has said that they don't believe the judiciary should substitute its opinions or expertise for what the military decides to do within its confines of how it operates. That's a very simplistic way of explaining military deference, and there's much more to it. But what we've specifically argued in this case, Rumsfeld versus Fair, is that military deference doesn't apply to this case because the Solomon Amendment is impacting civilian universities and civilian professors and civilian students. And even though military recruiters and the Solomon Amendment is the basis, the impact of the law is on civilians. If the Supreme Court believes that military deference should come into play here, we are arguing that military deference does not mean that the court abdicates its responsibility to do a constitutional analysis of the law itself, nor does the does the military or Rumsfeld abdicate his responsibility to prove that there is a nexus between the law and the reason for restricting such a fundamental right, such as the First Amendment. Some of the early briefs in Fair versus Rumsfeld were a little bit vague about military deference and where Fair and its plaintiffs believes military deference should play or not play, and we felt it was really important to make the arguments that military deference doesn't come into play so that future litigation about don't ask, don't tell, whether it's our litigation or any other litigation about don't ask, don't tell, is not adversely impacted by either a positive or negative decision by Fair. I hope that made sense.
We'll have this gentleman here.
So, excuse me. I'm kind of curious about the wisdom of these law school policies themselves, and kind of what I'm interested in is, it seems to me that in the military, gay members often are represented by people in the JAG Corps, and if we want them to have the best possible representation out there, shouldn't we allow JAG Corps the most possible access to the best law students out there, which means allowing them on campus, letting them advertise so that if they are down at the WADU, then people know about it. So I'm wondering, doesn't the policy itself actually hurt the interests of gay service members as opposed to helping them?
There's no evidence whatsoever that excluding the military from using career service hospitals in any way hinders military recruitment. That point was made powerfully by the majority in the Third Circuit. The reality is the military doesn't depend that much on recruitment at law schools in order to be able to get its lawyers. To the extent that it does do so, it still has all sorts of ways of communicating to law schools that it's just at the hotel or the ROTC building down the hall. So the assumption of your argument is that in some way the military is getting less lawyers or less good lawyers because of this, and there's just no evidence to support that. And that's exactly what the Third Circuit said. But I also, on a normative level, have problems with the assumption. Imagine that there's a law firm that refuses to hire African Americans. But that law firm does a lot of really good work. I mean, really good work in whatever realm. Should we say, well, but we really want that law firm to be able to get good lawyers who can do all this other good work? My answer would be no. That the law school should exclude that law firm that refuses to hire African Americans because the law school has to send a clear message to all of its students that it does not condone discrimination, that its facilities are available only to those who don't discriminate. And so even if what you were saying had some basis, and I don't think it does, I still would say the law school has to stick to the message that if an employer discriminates, it's not welcome to use law school facilities.
Emily?
In Westcott's detail and also thoroughly the Irish American was the Frey case, the courts seem to be going towards parsing a line between discriminating against an individual person and discriminating on the basis of expressing their message, their identity, etc. Like in the Hurley case, they said, well, you can walk in the parade, but you cannot hold a banner that says, that you're the gay and lesbian Irish American group. And I'm curious if using some of this precedent is going to kind of continue to push forward, drawing a line, which I think is a very problematic line, between discriminating on the basis of who someone is. Well, you can be in the parade, but if you express who you are, if you hold your partner's hand, or if you say a sign that you're gay, that's all right. And I'm curious how worried you are about the effects of continuing that kind of precedent, or depending on it.
I'd like to repeat the question just for the sake of the webcast audience. As I understand it, the concern is how we are developing a line between the identity of being a homosexual and the ability to express that in the public forum, and whether it is in fact a wise idea to use these negative anti-gay precedents to help further that line. The precedents referenced are the the Boy Scouts of America against Dale case and the Hurley against Irish American case.
Let me back up a bit in terms of the law in order to answer your question. The Supreme Court has generally said that anti-discrimination laws outweigh freedom of association. So in a case called Roberts versus United States Jaycees, the Supreme Court considered a Minnesota law that said that private organizations in that state could not discriminate, among other grounds, based on gender. And the Jaycees, a national all-male organization, said, we have freedom of association. We should be able to determine who our members are. And we decide we're an all-male association. Freedom of association gives us the right to exclude women. They lost in the Supreme Court. The Supreme Court said that generally, eliminating discrimination outweighs freedom of association. But the Supreme Court said there's two exceptions to that. One, the court called intimate association. My mental model here would be a small dinner party. If somebody wasn't invited to a small dinner party and they sued, it was really an intimate gathering. Freedom of association would protect the right to exclude. The other exception, the Supreme Court said, is where discrimination is integral to expressive association. In my mental model of that always was that the Klan can exclude blacks, the Nazi Party can exclude Jews, because the expressive message of those groups is inherently discriminatory. That was the issue in Boy Scouts of America versus Dale. And the Supreme Court said that the Boy Scouts have an expressive message that's anti-gay, so they can discriminate in furtherance of that message. The Third Circuit said last year that law schools have an expressive message that's anti-discriminatory, and they can exclude in furtherance of that message. And so, as I said to Ian's question earlier, I'm not troubled that if our side wins in Fair versus Rumsfeld, that's going to increase the ability to discriminate. I think it's just using existing law. Hurley is a bit different. I mean, Hurley, as your question rightly says, involved the St. Patrick's Day parade in Boston, in that they refused to allow a gay, lesbian, bisexual, transgender group to be able to march within it. And the Supreme Court, as a unanimous decision by Justice Souter, said that a parade is inherently conveying a message, and that those who put on the parade can control the message within the parade, and that therefore, if they don't want that message, they can do that. I think Hurley is different than this, because I think Hurley was less about association and more about controlling speech in a classic speech situation, a parade. I don't know that I fully answered your question, but that's at least how I would think about it.
And I just wanted to say from our perspective, what complicates the matter even more, and it's neither a pro nor a con to the fair litigation, but for us, what complicates the situation even more is that the case law, Don't Ask, Don't Tell was challenged in the mid-90s in multiple circuits, and the multiple circuits that heard Don't Ask, Don't Tell challenges all found Don't Ask, Don't Tell constitutional, mostly based on Bowers versus Hardwick. But a lot of the conversations and the arguments that occurred in those challenges were surrounding the status versus conduct distinction, or an artificial status versus conduct distinction that Don't Ask, Don't Tell created. And really, while it's not the first law, it's one of the first laws to have such a large impact that created this artificial status versus conduct distinction, which goes directly to your point about Hurley, which is the government's arguing you can be gay in the military, but you can't act or engage in conduct, and then defining conduct to be extremely broad, which we would argue includes status. Just being who you are in any way at all, showing that part of you, which is lesbian, gay, bisexual identified, makes you in violation of the conduct portion. And so it's a difficult area that's going to come up.
I completely agree. And let me say, I think Boy Scouts of America versus Dale was wrong, because I think it was wrong for the court to believe that the Boy Scouts had an expressive message that was anti-gay. It's just as Stevens pointed out in his dissent, you'd have to look in vain through all the Boy Scouts manuals to find anything about sexual orientation. The closest you could find is in an old manual. They're saying that Boy Scouts should be morally straight, and hard to believe they had sexual orientation in mind when they used that phrasing.
Right.
And I also don't believe that in any way you're interfering with the Boy Scouts' expressive message by enforcing the anti-discrimination law there. I think Hurley, though unanimous, was wrong for just the reasons you say. But I don't think you're making the law worse by saying, Well, based on these long-standing principles, law schools have an expressive message that's anti-discriminatory, and they should be able to exclude employers who do discriminate.
Lee?
Does FAIR distinguish at all between JAG Corps recruiters and ROTC recruiters?
The question is whether the FAIR case distinguishes between the JAG Corps recruiters and the ROTC recruiters.
And then as a follow-up, if FAIR prevails, then would universities be in a position to push ROTC on campus?
And the follow-up is whether then, if FAIR prevails, that universities would be allowed to remove ROTC recruitment and activities from their campuses as well.
To my knowledge, there's no distinction drawn in the suit between ROTC and JAG Corps. I mean, it was law schools saying within law school facilities, the military would not have access. If FAIR prevails, then if a university wanted to say, well, we're not going to allow ROTC on campus because of the military's anti-discrimination discrimination policy and law university's anti-discrimination policy, universities could do that. I mean, certainly there were a number of universities that excluded ROTCs during the Vietnam War.
Sure. And if I'm not mistaken, the underlying Solomon Amendment itself doesn't make a distinction.
Right.
How far can you push the First Amendment argument to other policies that DOD might have? I mean, you go from don't ask, don't tell to maybe women combat exclusion with regard to women to, though it's not a stated policy, there are areas of the military where, say, African Americans are grossly underrepresented or overrepresented, depending on what you're looking at. And to push even further policies that, you know, Iraq, what if we wanted to say that we disagree with the Iraq war? So how, I guess, do you see what I'm saying? How far can you push that argument?
I want to start with two premises. One is you're dealing here with a long-standing, well-established policy of law schools that they won't allow use of career service officers or law school facilities by employers who discriminate. This isn't something that was created just now. This is a well-established policy. And I think it becomes important as I go through your examples that because this has existed for a long time, I think it's important. And the second important distinction is between a de jure and de facto discrimination, that where the law says exclusion versus where there's a practice of excluding. Here we're dealing with a federal statute that excludes gays and lesbians from serving in the military. Now let me go through your examples with those two principles in mind. Imagine that FAIR wins, and or imagine even better that FAIR winning, that Congress finally repeals the statute that excludes gays and lesbians from serving in the military. Could a law school then say, but there's still a federal statute that excludes women from serving in combat? That's gender discrimination. We won't allow the military to interview here because if it's gender discrimination. I think it's completely the right of the law school to do because it's gender discrimination. It's interesting, law schools didn't exclude the military on that basis, but I think they should be able to do so. Your next example, well, what about the fact that African Americans are underrepresented in certain parts of the military, and for that matter, that African Americans are overrepresented in other parts of the military, especially particularly dangerous parts of the military? That's where the distinction between de jure and de facto becomes important. There are a lot of employers who interview at this law school where African Americans and Latinos and Asians and women are terribly underrepresented. And perhaps we should begin thinking about whether the law school should exclude employers not just to have an official discriminatory policy, but where there's discriminatory effects. That line between intentional discrimination and discriminatory effects is well established in the law. I don't think you need to get to that question with regard to the Solomon Amendment, because here you're dealing with de jure discrimination. The law, right on its face, excludes gays and lesbians. Then we can perhaps in the future talk about, well, what do we want to do about the military or any other employer where there's discriminatory impact without discriminatory intent? Final example you give, well, what about a law school that says we don't want the military there because we have an anti-war policy? If there was a articulated, established law school anti-war policy, in the way that there's an articulated, established law school anti-discrimination policy, I would say they could also do that. But it goes back to what I said with regard to my premise, it's not the same. I mean, this law school has long had a policy that it won't allow employers to interview if they discriminate. That's very different than tomorrow saying we don't like the war, so we're going to exclude the military.
Miguel?
Yeah,
just had a question for you. What do you think it's going to take for Don't Ask, Don't Tell to be overturned? Is it just a matter of time before younger people who have, by surveys, dramatically different views on homosexuality get to be in positions of power, or what do you think it's going to take?
I certainly think time. I do think in my lifetime it will end, and I think much sooner than that, unless I get hit by a bus. Interestingly, about 9 months ago, Annenberg did a study. It's very hard to poll the military. Annenberg was able to do a study of military members on social science issues. One of the things they included, and your satisfaction with your military service, one of the things they included was allowing people to serve openly, allowing homosexuals to serve openly in the military. And over a half of the junior enlisted members, which make up the vast majority of the military, and that's your 18 to 25-year-olds, over half of them said that they believe that people should serve openly and it wouldn't be a problem for them. The same study 10 years ago, it was less than 25% believed that people should serve openly. So, we have come a long way, baby, so to speak. Our lawsuit and any other lawsuit challenging Don't Ask, Don't Tell is going to take years to get to the Supreme Court. The Congress, by increments, we are making changes. Two of our co-sponsors on the House bill are conservative Republicans. One is Ileana Ros-Lehtinen, who's a member of the Hispanic caucus and considered to be very conservative amongst the Republicans, and she's a co-sponsor of the bill. Another co-sponsor, also a conservative Republican, is Wayne Gilchrist. Wayne Gilchrist is a Vietnam War veteran and also a Marine, a former Marine. He voted for Don't Ask, Don't Tell in 1992. He has publicly stated that he is a co-sponsor of the Military Readiness Enhancement Act because he was wrong in 1992. That people can serve in the military openly, and it would not be a disruption to good order, unit cohesion, and discipline to the U.S. military. Realistically speaking, over 70% of the countries that we are involved with over in Afghanistan and Iraq, we are partnering with other countries in our two engagements right now. Over 70% of those countries allow people to serve as openly gay. You have not heard one single instant where an openly gay British person has caused a problem for unit cohesion and discipline with American military members. And there are joint units, there are joint forces. So the more education that's out there, the more time, I do think that we're going to see a change.
Any other questions from the field? Well, I'd like to follow up with one final question, if I may. And this is for each of you. We've heard the arguments that have described why Don't Ask, Don't Tell and why the Solomon Amendment are putatively unconstitutional. It would be wonderful if each of you could talk about what the government's arguments are on the other side to say that it is constitutional.
Starting with Don't Ask, Don't Tell. Really, the government's historical arguments are that people serving as openly gay, and let me be very clear, we're not talking about feather boas and rainbow pride parades down the center of Fort Bragg. We're just talking about being able to talk about what you do on the weekends. That you play on a gay softball team, or that you visited a good friend of yours who just had a civil union commitment in Vermont. The historical argument from the military has been that people serving as openly gay will be a disruption to good order, unit cohesion, and discipline. They have tweaked their argument a little bit in our case by saying that if people serve as openly gay, it will cause sexual tension in the units. And that sexual tension is what will cause the disruption to good order, unit cohesion, and discipline. They haven't really defined very well what that sexual tension is. Is it that the gay people are going to be predatory? Or is it that the straight people are going to be afraid that the gay people are going to be predatory? they are a little bit more vague in what they are defining as sexual tension. So I don't necessarily know if that answers fully the question. But again, from our perspective, they don't have a leg to stand on because every argument they have made has been disproven, one, by their own research and also by social science research on every other military that has lifted their ban in the last 15 years.
The government's key arguments in the Solomon case are deference to the military. They also say that it would hurt military recruitment to not allow the military to have access to law school career service facilities. This is a time of war, and especially at a time of war, the court has to be deferring to the military and to the judgments of Congress. There's also an argument that says that this is Congress giving money, and Congress should be able to put the strings on grants. And they also deny that law schools are being compelled to express any message or that law schools' associational rights are being interfered with.
Well, thank you. And with that, I would like to thank all of you for coming, and please join me in giving a hand for our speakers.